Ladies and gentlemen, good morning. Call to order the Cannabis Compliance Board for the October 25th, 2022 meeting. The first order of business is a roll call to make sure we have a quorum.
Right, Member Merritt,
Present.
Member Durrett,
Here.
Member Nylander,
Here.
Dr. Young, here, and Chair Douglas.
Here. Before we get to our public comment section, number one, just for purposes of our agenda, under item number 3, consent agenda, item 3B, conditional approval of request for transfer of interest, Polaris Wellness has been removed at the request of the applicant as to this meeting. Additionally, item number 5, D, E, F, and G of Las Vegas Wellness and Compassion LLC has been removed at the request of the applicant. They will be both items will be continued to another meeting. With that, we'll go with our public comment here in Las Vegas.
It's short today. Good morning. Good morning to the entire Cannabis Compliance Board and everyone in this building today. My name is Rachel Lee and my company is Sunflower Compassionate Company. First, I would like to say thank you again to the entire board for taking on a task of attempting to figure out the rules, regulations, and laws without jeopardizing legal actions. You have put up with all kinds of suggestions and feedback in order to do what's right. So I say to the entire board, staff, you are appreciated. Today, I time myself, Honorable Douglas, to less than 3 minutes, if it's okay with you, sir. So I will try to be quick, but this message is not for the Cannabis Compliance Board, but for the predatory investors that are looking to come up on a quick social equity license holder. So I say to you, I am pretty sure I'm not the only one in this room who has a friend, a mother, a cousin, a father, uncle who has Alzheimer's disease, Parkinson's disease, multiple sclerosis, cerebral palsy, depression, addiction, AIDS, cancer, and the list goes on and on. The studies of the Rick Simpson oil, as known as RSO, is astonishing. So to the predatory investor who wishes to prey on a social equity applicant, please know that if some miracle happened and I am chosen, I'd rather sit in a small hut in compliance with the Cannabis Compliance Board and make $1 a month before I ever allow you to water down what the board has attempted to do for social equity. If I am not selected, the show still must go on due to the fact that Alzheimer's disease is hereditary in my family. I have no choice but to fight before I forget how to. So when a predatory investor are attempting to make bogus operation agreements with social equity applicants while you're trying to make money from the tourist that wants to, as we say in the hood, get it on the floor, please understand that here in Nevada, Las Vegas, we still have family that are depending on medical research that could possibly cure you and me. So I ask again, if the CCB gives it to us, what are you going to assist us with us doing with it? When it's all said and done, and the club tourists and the club goers and the cannabis convention stoners go home, we still have a life to live here in Nevada with family members depending on us. Also, Safe Base is my nonprofit organization that will assist kids in foster care and treatment centers with the opportunity to have extracurricular activity or academic achievement added to their already existing program by paying for uniforms, registration, cost of volunteers, insurance, and transportation. If you are not looking to be a part of that, if I am chosen, then you are barking up the wrong tree. Thank you for letting me speak. Thank you.
We have anyone else for public comment in Las Vegas?
Good morning, Lake Martin on behalf of the Nevada Cannabis Association. On behalf of our members, I wanted to express concern about the interpretation and application of the facility ID and name requirement on certain in-store signage at licensed dispensaries. I raise this issue now because licensees are currently being issued warnings and deficiencies during regular inspections since the CCB's policy went into place on September 3rd. The current interpretation of the regulation, which is 12.070 sub 3, is extremely burdensome for licensed businesses and runs contrary to what was intended by the legislature in Assembly Bill 326. AB 326, sponsored by Assemblyman Tom Roberts, was intended to create additional tools to seek civil penalties against unlicensed cannabis businesses. It was also intended to help tourists and law enforcement distinguish between advertising by licensed and unlicensed companies. Roberts proposed that marketing materials contain a licensee's name and ID similar to the Contractors Board requirements, which he intended that similar to contractors, an individual could face civil penalties for marketing their services without a license. Assemblyman Roberts made clear during testimony on the bill that his intent was not to create additional burdens for licensees. This was the clear legislative intent. However, what's been happening is that licensed dispensaries are receiving deficiencies from CCB inspectors for not having their facility ID and name on every single in-store sign, menu, placard, piece of paper, etc. The bill was intended to apply to marketing materials, not in-store signage and menus inside licensed dispensaries. Now, this isn't necessarily the fault of overzealous inspectors. The definition of advertising adopted in the regulation some months after the passage of AB 326 is very broad. We objected to it at that time for that reason. There are numerous issues with the definition of advertising that we've raised to staff, such as whether swag items like stickers, hats, lanyards, and other merchandise is considered advertising. Additionally, we've asked for clarification whether in-store signage, which is only seen by people who are over 21, should be required to have the warnings like keep out of reach of children. The issue with the facility ID and name is another issue resulting from this overbroad definition of advertising and the application of the rule that we believe is contrary to legislative intent. The only companies facing fines as a result of this policy are licensees, and that's directly contrary to what the legislature intended. We'd ask the board to reconsider its definition of advertising in NCCR 1.052 and its application of NCCR 12.0703. If this is something that can't be resolved by issuing written guidance, we'd be happy to bring a petition or request for declaratory ruling to the board. Thank you.
Additional public comment, Las Vegas.
Good morning, board. My name is Christina Ullman. I'm the co-founder and president of the Chamber of Cannabis, Nevada's most diverse industry trade association, comprised of businesses, professionals, and activists working to build a more conscientious, inclusive, and thriving industry. I wanted to use my time today to follow up on the suggested solutions and revisions that were offered and discussed during the industry roundtable about less than 60 days ago. Along with 15 other industry professionals and Chamber Board member David Holman and myself, we shared numerous solutions that would help alleviate unnecessary costs for cultivators, producers, retailers, consumers, and patients, ultimately making it easier to operate in Nevada and support a struggling legal market. A few suggestions that we asked the board to take into consideration are the following: revising fair market value calculations, reducing time and effort billing to no longer include research time by the investigators, revising testing lots from 5 pounds to a minimum of 25 pounds, revising numerous packaging regulations to reduce waste that ultimately end up in Nevada's landfills and on our beautiful streets and are usually single-use plastics, revising the pre-roll tax, revising the acceptable microbial levels to increase quality of flower and make us more competitive against the California market, creating a more collaborative resource line for the industry to have as a tool to ensure regulations are followed correctly. We respectfully ask for the board to consider these solutions as soon as possible. Our coalition will gladly continue to work with the CCB to provide insight for the opportunities that matter and we see improvement on. Thank you.
Any additional public comment in Las Vegas? Hearing none, do we have any public comment in Carson City?
Hello, my name is Will Adler, and I am the director of the Sierra Cannabis Coalition, representing them as the primary lobbyist of Silver State Government Relations. I want to thank the CCB for the time they spent with me last week discussing the petition I'm going to file and some of the efforts we've been going forward with. And I wanted to reiterate and back up the comments by Lake Martin there when it comes to advertising and the relations there. It was specifically made to address illegal or outside advertising, and again, has been, the exact opposite effect in reality, where we've been seeing it applied to only the license holders in the industry. And we've had comments from local governments like Carson City, whereas they don't want to see extra advertisements on our, pickup and delivery signs for our curbside delivery, because they thought of it as excess advertising or extra signage on the outside of the building. Yet we were told we must have signage labeling itself as this company's on the outside of the building. So it's in, direct confrontation with the local government. So please do address that and look at that in depth where you can. Thank you very much.
Additional public comment, Carson City.
Doesn't appear to be any additional comment here.
Do we have any additional comment, public comment online? If not, we will close first round of public comment at this time. And we will move to agenda item number 2, meeting minutes. We have 2 sets of minutes. We have minutes from our continuation of special meeting, and as well as our regular board meeting of September 27th, 2022 for consideration by board members. If they've been reviewed, if we can have a motion.
I move that we approve the minutes of September 15th, 2022.
A motion for approval. Do we have a second?
This member Young, I'll second that.
We have a motion, we have a second. All in favor of approval of the minutes, please say aye.
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 Any nays? Any abstentions? Motion carries unanimously. With that, we can move to item number 3, consent agenda. Complaints, item A.
Thank you, Chair. Item 3A on the agenda concerns 2 complaints for disciplinary action pursuant to NRS 678-8510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. I'm requesting the board's approval to proceed with each of these 2 disciplinary actions, and if approved, I will then authorize service of the complaints. And once the board has approved proceeding with disciplinary action, service will proceed within a reasonable time. Once these are out for service, they will be posted online. As to respondent A, the complaint will allege violations of NRS 678B-385 and NCCR 4.035. And as to respondent B, the complaint will allege violation of NRS 678B-385 and NCCR 4.035.
With that, do we have a motion?
Member Drat, I move to approve the issuing of complaints under the consent agenda items 3A, 1 and 2.
Do we have a second as to that?
Member Merritt, I second.
It's moved and seconded. Any additional discussion? If not, all in favor, please say aye.
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 Any opposed? Any abstentions? Matter carries unanimously as to both items 1 and 2 under consent. That moves us, item B, as indicated previously, was taken off, which was Polaris Wellness. Takes us to item number 4, consideration of proposed settlement agreements to resolve disciplinary actions. The first matter up is item A, Cannabis Compliance Board versus Psychic One LLC.
Morning, Chair, members of the board. L. Christopher Rath, Senior Deputy Attorney General. I will be handling this first matter, and Ms. Bordelove will be handling the second one. Again, under agenda item 4A, we have the case of CCB versus FISIS One LLC, CCB case number 2022-101. This licensee, FISIS, is a medical and adult use cannabis cultivation facility. The complaint in this case was filed on August 12, 2022. Respondent has not yet filed an answer at this point, but rather, as an agreement in principle was reached for resolution subject to CCB approval, the disciplinary process was stayed to allow an agreement to be prepared for the board's consideration today. The allegations in the complaint arise from an audit and inspection of this licensee that took place in August 2021. These include a failure to meet the requirements for disposal of cannabis waste, failure to keep required records, failure to comply with seed-to-sale tracking requirements, failure to properly wash and sanitize product contact surfaces, failure to properly store cannabis, failure to ensure processes designed to prevent contamination, and failure to ensure all items were stored at least 6 inches from the floor. As indicated in paragraph 9 of the settlement agreement, the CCB staff and the Attorney General's office did consider the factors set forth in NCCR 4.030 subsection 2 in determining the appropriate admissions and civil penalties. More specifically, there was a previous investigation finding of improper disposal of cannabis waste in November 2018, so that was a prior issue with the licensee. There were several other but smaller violations found in that 2018 investigation and again in 2019, but no disciplinary actions had been instituted for any of those prior issues. On the positive side, respondent quickly worked with the CCB staff to come up with and implement an approved plan of correction for all of the issues found during the August 2021 investigation. Respondent also cooperated with the CCB's counsel in coming to a negotiated resolution without the need to file an answer, and thereby saving resources for the state. In addition, the parties agreed to a short payment plan for the civil penalties, which will allow for a full payment and also take into account the timeline for the respondents' harvests and their receipt of revenues from those harvests. The parties negotiated in good faith to come to this agreement upon resolution, which is acceptable both to the CCB staff and the Attorney General's office. As set forth in the proposed settlement agreement to resolve this case, respondent will admit to one Category 3 violation for failing to keep required records and failing to meet the requirements for disposal of cannabis waste. A second Category 3 violation for failing to comply with seed-to-sale tracking requirements because respondent was unable to reconcile its physical inventory with the information it had entered into metric. A Category 4 violation for failing to properly wash and sanitize product contact surfaces, and lastly, 2 Category 5 violations for failure to timely submit required reports to the board. Respondent has also agreed to pay civil penalties in the total amount of $42,500. As I noted before, this is on a short payment plan, which is set forth in the payment schedule in paragraph 17 of the agreement. If the board approves this agreement, respondent will pay $17,500 within 2 weeks of today, and thereafter the remaining payments would be in equal installments and spread out over the following 4 months thereafter. Respondent has also provided a plan of correction, which is detailed in paragraph 19 of the settlement agreement. The CCB staff has reviewed this plan of correction and has approved it. In summary, the plan of correction includes the following. First, respondent has implemented the use of a plant destruction log, will maintain copies of all harvest logs, and has commenced the use of cleaning logs, as well as ensured that the product contact surfaces have been properly cleaned. Respondent has properly destroyed the cannabis plants that were improperly designated in the metric, and the reports that were not initially timely provided to the CCB have been provided. Based on the foregoing factors, the Attorney General recommends and requests the CCB approve this settlement agreement. I am available for any questions, as is the respondent and his attorney, Mr. Brian Hardy.
Before any questions are put forth by the board, can we hear from our licensee or counsel?
Thank you, Chair, members of the board. We appreciate your time today and the diligence of the staff in their investigation here and working with us. Obviously, Mr. Rath has done a wonderful job describing what the situation was, and we were able to come to a resolution fairly quickly in this matter once we were able to discuss all the factors that were going into this particular issue and the plan of correction in particular that we were willing to undertake. We appreciate your consideration in this matter, and I have with me Kelly Hurst, who is the owner of the facility. Thank you.
And did you state your name for the record so we don't
Yep.
get hollered at?
Brian Hardy with the law firm of Marquis Arbach. Thank you.
Thank you. Any questions by the board as of this? If we have no questions, can we have a motion?
Mr. Chairman, this is Member Nylander. I would move that the board approve the settlement agreement in the matter of item 4A.
We have a motion for approval as of 4A. Do we have a second?
This member
Member
Young, I'll
Merritt,
second that.
Motion, we have a second. Any additional discussion? Hearing none. All in favor, please say aye.
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 Any nays? Any abstentions? Matter carries. Thank you very much.
Thank you so much for your time.
That moves us to item B, Cannabis Compliance Board versus this is Pixie of Reno LLC.
Thank you, Chair. That's Emily N. Bordelov, Senior Deputy Attorney General, for the record, for item 4B, Cannabis Compliance Board versus Pixie Reno LLC, otherwise known as Pixie, case number 2022-96. Pixie's counsel, Michael Cristalli, is present representing Pixie, along with a representative from Pixie to answer any of the board's questions. Pixie holds a medical license and adult use license for dispensaries, facility identification numbers D106 and RD106. The settlement agreement originates from a complaint filed and served on July 14th, 2022. The matter has been stayed to allow the parties to come up with the settlement agreement in front of you. The violations alleged in the complaint include, in summary, offering cannabis or cannabis products as free without purchase, thus either selling cannabis not found in the seed to sale tracking system or diverting cannabis or cannabis products, and or failing to keep required records, failing to maintain required security alarm and surveillance systems, failing to meet requirements for the disposal of cannabis waste, and failing to keep required records, including seed to sale tracking requirements, failing to establish and implement an inventory control system, an agent failing to display or have in his immediate possession a cannabis establishment agent registration card or proof of temporary registration, failing to maintain hand washing facilities, and failing to file monthly sales reports. None of the violations I've listed above relate or stem from self-reported incidents. As indicated in paragraph 10 of the settlement agreement, to resolve these matters, Pixie has admitted to one category 3 violation for improper waste disposal under NCCR 4.0501A14, a second category 3 violation for failing to keep any required records, including seed to sale tracking requirements under NCCR 4.051A3, and one category 5 violation for failing to properly submit quarterly inventory reports, monthly sales reports, or other reports required by the board under NCCR 4.0601A7. Pixie has agreed to accept a formal warning for the first category 5 violation and pay $40,000 in 2 installments, the first $20,000 to be paid on December 28th, 2022, and the remaining $20,000 to be paid on January 30th, 2023. Pixie has also provided a plan of correction summarized in paragraph 18 of the settlement agreement, and CCP staff has approved this plan of correction. In summary, the plan of correction includes, first, the requirement for staff meetings reviewing policy and procedures regarding test samples and cannabis waste, increased management monitoring, updated standard operating procedures, and that the employee responsible for those issues is no longer employed by Pixie. Second, respondents has ensured cameras now have time and date stamps. Third, for the API key errors, Pixie's addressed the point of sale system API issues, which it believed caused communication problems with Metric. Fourth, Pixie identified some of the import issues that stem from ownership and been working with Metric and the CCP to remedy this issue in a recent quarterly inventory report form confirmed accurate on hand amounts. Fifth, the delay with obtaining the dispensary agent card was reconciled and addressed. Sixth, the faulty hot water heater was replaced and is now working properly. Seventh and finally, Pixie has had a new employee handling quarterly reports who will reach out to a seller to ensure reports are uploaded and will continue to send the quarterly inventory reports as required. As indicated in paragraph 9 of the settlement agreement, in settling this matter, the executive director for CCB and counsel for the CCB have considered the factors set forth in NCCR 4.0302, including the gravity in the violations, the economic benefit or savings, if any, resulting from the violations, the size of the business of the violator, the history of compliance with NCCR Title 56 and NRS by Pixie, actions taken to remedy and or correct the violations, and the effect of the penalty on the ability of Pixie to continue its business. More specifically, with regard to Pixie's compliance history, this is Pixie's first complaint after acquiring these licenses in March 2021. Other many factors here include that Pixie cooperated with CCP's counsel in resolving this matter shortly after the complaint was filed, so no answer was filed and we were able to stay and settle the matter. The executive director for the CCB and counsel for CCB also considered the size of Pixie's business and the impact of civil penalties on its ability to continue its business. Accordingly, a reasonable civil penalty has been proposed in this agreement based on the factors outlined above. So based on the facts of the case, the foregoing corrective action submissions, the Attorney General recommends and requests CCB approve the settlement. I'm available for any questions as his counsel for the licensee and representative of the licensee. And with that, I submit.
Thank you. On behalf of the licensee.
Thank you, Chairman Douglas, members of the board. Just want to take an opportunity to thank Ms. Bordelov and Ms. Balducci for in the Attorney General's office to working with us in regard to resolution of the matter, as well as the CCB and Mr. Klimas in taking into consideration all the information that the licensee provided in mitigation of the underlying complaint. As Ms. Bordelov had indicated, this was a company asset that was acquired through a transfer of interest. At the time that acquisition was made, management from the previous ownership was left in place. Subsequent lead to that, management has been changed and standard operating procedures consistent with the parent company have been implemented. Stacy Jackson, the manager and compliance officer of Pixie Reno, is present with me here today, and I'm available to take any questions from the board.
We know who you are, but if you'd state your name for the record. And counsel.
Michael Cristalli on behalf of Pixie. I'm sorry, Your Honor. I should know that, shouldn't I?
Questions by the board?
Mr. Chairman, this is Member Nylander. Just wanted to get from the licensee confirmation that they're in compliance with paragraph 18, which is the correction plan.
Yes, we are.
Thank you.
If there's no further discussion, if we can a motion.
This is Member Young. I'll make a motion. We approve agenda item 4, the proposed settlement agreement between the Cannabis Board, Pixie Reno, case number 2022-96.
We have a motion for approval under item 4B. Do we have a second?
Member Merritt, I will second.
Moved in second. I'll ask one more time, any additional discussion? If not, all in favor, please say aye.
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 Any nays? Any abstentions? Matter carries unanimously. Thank you very much.
Thank you.
Good luck.
Thank you, Chairman. Thank you, members of the board.
This now moves us to item number 5, request for consideration of approval of service agreements.
Good morning, Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Division Chief of Investigations for the CCP. I'm here to present agenda item number 5, which consists of 3 service or management agreement applications, or MSAs. Item number 5A includes review of the 4th amended lease agreement between Integral Associates LLC as tenant and Cheetac Development Inc. as landlord. CCB staff have reviewed the agreement and found it appropriate. I am available for any questions, and my understanding is that Amanda Connor, Anthony Georgiadis, and Brendan Bloom are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Ms. Connor?
Good morning, Chairman, members of the board. Amanda Connor from the law firm of Connor & Connor on behalf of my client Integral Associates LLC, and appearing via Zoom today is Mr. Brendan Bloom, who is the VP of Experience Real Estate and Facilities for Green Thumb Industries, Inc. We kindly request approval of this lease agreement, and we are here to answer any questions.
I take in this case because we're talking about a 10% above a certain threshold. There was no need for any additional investigation.
No, sir, this is David Staley for the record. This is a lease agreement that's been put in place. And I believe our understanding was that the initial lease amount was lower in comparison to potential rates, giving the opportunity for the licensee to get good cash flow with the operations. And then depending on the success of the operation, that's when the higher amounts came in place, which staff believes is a benefit to both the licensee and the landlord.
Any other board member wish to inquire or satisfied with this?
Yeah, Mr. Chairman, this is Member Nylander. Just for Ms. Connor, are you finding that these agreements are starting to be more standardized, or are they sort of one-off, every one of them's different? And I'm not talking just about your current agreement, but just your experience overall.
Amanda Connor for the record. As you all are aware, this is still a fairly new and young industry, so the agreements are still kind of sporadic, but I do find in my representation that they are becoming more standard. So I think we'll start to see in the next year or two some more standardization among these agreements.
Thank you for that. I'm just curious about the maturation, sort of process and how you see it from your side. So that's helpful for me.
Any other board member wish to pose a question or a comment? If not, can we have a motion for approval?
Member Durrett, I move to approve the relationship proposed under agenda item 5A relating to Integral Associates.
I have a motion for approval as to the service agreement. Do we have a second?
Member Merritt, I second.
It's been moved in second. Any additional discussion? Statement for the record. If not, all in favor, please say aye.
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 Any nays? Any abstentions? Matter carries unanimously. Thank you.
Thank you, and thank you to staff for their work on this.
That moves us to item number B.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief Investigations for the CCB. Item 5B includes review of the management services agreement between Nature's Kindness LLC and Kindles LLC, both with Mint Nevada LLC. This management agreement is anticipated to be in place until the TOI filed by the parties requesting an acquisition by Mint is completed and presented to the board. CCB staff have reviewed the agreement and found it appropriate. I am available for any questions, and my understanding is that Alicia Ashcraft, Stephanie Meehan, Evans Shahara, and Nick Scavio are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
On behalf of the licensee.
Good morning, Chair Douglas, Director Klimas, members of the board. Alicia Ashcraft, the law firm of Armstrong Teasdale, on behalf of the applicant Mint Nevada. Appearing virtually with me today are owner Ivan Shahara and General Counsel Nicholas Scavio. Happy to answer any questions that the board may have as to this management services agreement. As Chief Staley indicated, it is an interim management services agreement pending the acquisition approval of the transfer of interest. Respectfully request your approval. Thanks so much.
Any questions by the board?
Mr. Chairman, this is Member Nylander. Just for Mr. Staley, what's the timing, do you think, on the TOI?
David Staley for the record. Member Nylander, you've caught me on that one. I have no idea. I can't help you on that one at all. I know that we're Alicia, do you know if it's been assigned?
I do. It's actually Rachel Branner has it. She processed the management services agreement and is also working on the transfer of interest. We owe her some stuff, so I think the holdup is us. So we don't anticipate that it'll probably take more than a couple of months. If it's not by the end of the year, then probably just after the first of the year.
Thank you, Alicia. David Staley for the record. Member Nylander, I would expect that December would be difficult because both November and December happen earlier in the month. But it sounds like January would be very possible.
Thanks, Ms. Ashcraft. And thank you, Mr. Staley, for your honesty. You don't know what you don't know. I like to hear that sometimes. I didn't have anything further, Mr. Chairman.
Thank you. Well, with those comments, I'll keep straight. Do we have anything else by the board? If not, can we have a motion for approval?
Member Drat, I move to approve the relationship proposed under agenda item 5B relating to Nature's Kindness LLC.
We have a motion. We have a second. We have any additional discussion or statement for the record? Hearing none at this point. All in favor of approval, please say aye.
Aye.
Aye. Aye.
Aye.
Any nays? Any abstentions? Matter carries unanimously. Thank you very much.
Thank you, and thank you to Investigator Branner for her work on this application. Thanks so much.
That takes us to item number C, SSAC Corporation.
Chair Douglas, member of the board, this is David Staley, Chief Investigation of the CCB. Item number 5C includes a review of the production agreement between SSAC Corporation and Meta Medical Inc. CCB staff have reviewed the agreement and found it appropriate. I'm available for any questions, and my understanding is that Adam Fulton, Stefan Haller, and Christopher Emerson are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Good morning.
Morning, Chairman, members of the board. Adam Fulton, the law firm Jennings and Fulton here representing SSAC. Stephen Haller is appearing up in Carson, I believe, and Chris Emerson, the CEO and founder of Meta, is also appearing today via Zoom. If you have any questions for me, I'm happy to answer it. Otherwise, would request approval of the agreement.
Again, as my previous question, we have his payments for services, net profit will be split 50-50. With the split, SSAC will receive 50% and Meta will receive 50%. Again, is there any need to look at backgrounds, or have we previously looked at backgrounds of the new parties?
Chair Douglas, David Staley for the record. Our review of MSAs does include a background review of the companies. Of course, it's abbreviated from what you would expect with a TOI. I will note that there are 4 employees from Meta that will be present on SSAC. Our understanding is those employees are there to get the production facility up and running and to train the SSAC employees, at which time the operations will be run by SSAC employees with Meta available for quality control purposes if necessary.
Thank you.
That is correct.
And I additionally note that this agreement is for 6 months, automatically will renew or can be terminated by either party. Any other questions by the board or comments? And much like Mr. Nylander's question earlier, we're starting to look at these as either a pattern or one-offs. We're trying to figure out where we are with these service agreements because we're getting more of multiple players. Some licensed in our system with full background checks and others outsiders, which we have to take a good look at. But with that, can we have a motion for approval?
Member Drat, I move to approve the proposed relationship relating to SSAC Corporation under agenda item 5C.
We have a motion for approval. Do we have a second?
Member Merritt, second.
We have a motion. We have a second. Any additional discussion? All in favor, please say aye.
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 Any nays? Any abstentions? Matter carries unanimously. Thank you very much.
Thank you.
As indicated previously, items D, E, F, and G as Las Vegas Wellness and Compassion are off of this agenda. Moving to item 6, consideration for approval to extend final inspection deadlines.
Thank you, Chair, and good morning to you and members of the board. Steve Gilbert, Chief of Administration for the record. I'm here today to present agenda item number 6, which consists of petitions submitted by conditional licensees to extend the deadline to receive the final inspection by the CCB. Agenda item 6A is for Nevcan LLC. Nevcan LLC applied for and was issued a conditional adult use cultivation license on September 24th, 2018 in the Las Vegas jurisdiction. On December 13th, 2021, Nevcan, through its legal counsel, submitted its first request for an extension for the February 5th, 2022 deadline. Nevcan's request went before the board at its January 25th, 2022 meeting. The board granted an extension to Nevcan's conditional adult use cultivation license to February 5th of 2023. On October 6th of 2022, Nevcan submitted a second request to extend the February 5th, 2023 deadline for the final inspection of its conditional adult use cultivation facility for 9 months, which would be to November 5th, 2023. The request mentions both 9 months, the request mentions both its medical and adult use cultivation license, which are in the same building. However, since the medical license did receive final inspection in August of 2018, this request is only for Nevcan's conditional adult use cultivation license. In its latest request, Nevcan reports that it has received a special use permit for the build-out of the cultivation facility at its approved location, but indicates it has run into difficulties getting final permitting from the city of Las Vegas. Once the building permit is issued, Nevcan anticipates the remaining construction and inspection steps will take approximately 8 months, 3 months for the permit and change order process, and 5 for phase 2 construction completion and required inspections. Nevcan reports it has begun construction and made best efforts to expedite this process and has worked in good faith to complete the project. Based on the foregoing, Nevcan requests the CCB grant it an extension for a period of 9 months to perfect this license. Staff has communicated to Nevcan that there are no areas of concerns and has asked the licensee to be prepared to discuss its progress at the board. I'm available for any questions, and James Dillingham and Adam Fulton are present today to give a brief presentation and address any questions you may have.
Thank you. Good morning, and can we have representations and kind of a synopsis of where you're at with the second phase of your building?
Yes. Thank you, Chair and members of the board. Adam Fulton, the law firm Jennings and Fulton, representing Nevcan today. I have with me James Dillingham, who's the representative for Nevcan, and Rob Gertison, who is our architect of Rob Gertison Architects. So I will let Rob actually kind of give you a short synopsis of kind of where we're at, and then if you have any other questions for James, who's overseeing the construction aspect, he'll address those as well.
Hi, Rob Gertison for the record. Thank you for hearing our case. And I was here last time, February 5th of last year, to present our case. Right now, we've been held up at the building department, which we've been working very successfully with them through Public Works. We now, as of yesterday, have a permit to move forward, and we are fully funded. We are ready to move forward. We're ready to finish the project.
Questions by board members?
with these independent cultivations, they've really struggled. And from the beginning, it was kind of patently obvious that if you didn't have a dispensary, it was going to be very difficult. And then they put in a lot of money and they're still struggling 7 years later. And they now sales are down and they blame the state. They say it's because they don't have a dispensary. So how's yours going to be different? How do you plan to make it if you don't have a dispensary and there's a lot of competition out there?
What, as the architect, maybe I'll defer that question to council, which.
Yeah, you can answer. Go ahead, James. Okay. I'll try to answer that question. So,
Rob.
So this is James. Yeah. So I think they answered the question and I represent a lot of smaller cultivators. And I think a lot of the cultivators obviously have concerns over the industry. Many of them are set to shut down and close based on what's going on in the industry right now. The hope is that there is a way to get the market back on track, right, with either higher production of better quality product, or frankly, as cultivators close, it will provide more opportunities for others, right? I mean, that's just the reality. Is if there's less material in the market to sell, then there will be opportunities for others who can survive. And I think a lot of that's going to be based on the company's debt structure, their ability to finance operations, their ability to move forward. If that somewhat answers your question.
Yeah, I guess it's also a comment that, like, fair warning, that in a few years, you may be in the same situation as other independent cultivators right now. And I don't think the complaint at that time should be that it was because you didn't have a dispensary or because the taxes were too high or something else that's currently in place. So, yeah, that's it.
Any other board member wish to raise any questions for our staff or for applicants?
Yeah, so just to follow up, Mr. Chairman, this is Member Nylander. Mr. Fulton, so I know you've had some experience in the gaming industry also. And so for this, I mean, I have no issue with if this applicant has the finances, to give it a go. In the gaming industry, people fail all the time. And, I love the fact there's open competition. So I don't, and again, part of our task has been to try to mold this similar to the gaming sector. And it's different here because there's a limited number of licenses, but at least in the gaming sphere, it's open competition. If you can prove you're suitable and you have the financial capability to get going, so some fail and some don't. So I'm okay with it.
Yeah, Adam Fulton again for the record. I think you're right on point and correct. I mean, I have some cultivators that are barely making a buy, and I have some that are doing fairly well. I think the market as a whole I think everybody knows the market as a whole is suffering right now. And we're hoping that there can be some corrections made in the market to get everybody back on track. That's the hope.
Yeah, no, and I think that's part of the maturation of the industry. It's still a very, new industry for Nevada. And, I've kind of witnessed this in the gaming industry as well. And it's just part of that maturation process. I didn't have anything else, Mr. Chairman.
A very big opening has been made in terms of where we're at. Yes, we are still a new industry. We are hopeful based on what gaming is doing. Their numbers have seemed to have bounced back very well, and they're expecting a good year coming. Our numbers from last year were just 4% off the previous year, and we hope to get back above those numbers. So with that, I ask, do we have a motion for approval?
Member Durrett, I move to approve the requested extension under agenda item 6A. Do we have a specific date we want to make it for?
Your request to November 5, 2023.
Okay, we don't want to bundle it with the other ones. Okay, so the new date would be November 5, 2023.
With that, do we have a second?
Member Young, second that.
The motion, we have a second. We have any additional discussion? All in favor, please say aye.
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 Any nays, any abstentions, matter carries. Good luck. And
Thank you.
Thank you.
that moves us to item C. D. B.
Thank you, Chair. Agenda item 6B is for Wellness Connection of Nevada LLC. Wellness Connection of Nevada LLC, or Wellness, was issued a conditional adult use retail store license on December 5th, 2018, within the Las Vegas jurisdiction. On August 18th, 2021, Wellness submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline to November 4th, 2022. In the request, they outlined the circumstances surrounding the approval of their special use permit by the Planning Commission and subsequent denial by the Las Vegas City Council. On September 14th, 2022, Wellness submitted a second request to extend the November 5th, 2022 deadline for final inspection of its conditional adult use retail store facility to November 5th, 2023. In the latest request, Wellness reports that its legal dispute with the city of Las Vegas over the issuance of the special use permit is ongoing. Staff have communicated to Wellness that there are no areas of concern and has asked the licensee to be prepared to discuss its progress at the board meeting. I'm available for any questions, and Matt McClure and Christopher Rhodes are present today to give a brief presentation and address any questions you may have.
Representations for the record, please.
Yes, thank you. Good morning, Chair Douglas, members of the board. Christopher Rose from the law firm of Howard and Howard Attorneys for Wellness Connection of Nevada LLC.
And Matt McClure on behalf of Wellness Connection of Nevada LLC.
Are you back in district court or are you up at the Supreme Court as to the second round?
We are back in district court. Would you like me to give some updates? Yes. Thank you, Christopher Rose, for the record. As of the last time we were here, we were in the Supreme Court. The district court had granted us a writ of mandamus and also judicial review as a result of what we believed was an unfair hearing and application process the first time around. Since the last time we were here before this board, the Nevada Supreme Court denied the city's petition for a writ seeking to overturn the district court's order to require a new city council hearing, finding that that was not an appropriate request at that time. Since that time, and that was on March 13th, 2022, the city held a new city council meeting on April 20th, 2022, where they considered the application for a special use permit again. At that time, we had 3 city council members vote in favor of approving the special use permit, specifically noting that it is discriminatory to have these dispensaries limited to wards 1, 3, and 5, and that there should be a dispensary in Ward 2, as well as in other wards of the city. Another council member noted that it's a matter of equity and that it should be approved. Because the council person whose conduct gave rise to the legal proceedings was still participating, it resulted in a 3-3 vote, which under the city guidelines resulted in a denial. We then filed a new petition for judicial review and for mandamus on May 13th, 2022, under the case law, and we've cited it in our letter,
The case law states that if there's a person who has been prejudiced or biased, that, or if there's even a risk of unfairness, that person should not participate. So that is the issue that we are now briefing back in district court. I will update, since we submitted this letter request, the briefing schedule has been set. We will be submitting our opening brief on November 8th. The city will be responding by December 15th, and then we'll have reply briefs January 16th. We're hoping to get it set for hearing and for decision as soon as possible in the district court after that. Again, if the makeup of the city council would have been as we believe it should have been, it would have been a 3-2 approval at this last meeting. So based on that, we respectfully submit that good cause and extenuating circumstances exist for this request for an extension. I'd be happy to answer any other questions.
Without getting into particulars, has there been any attempt for settlement outside of litigation or within litigation?
Yes, there has been, Your Honor. We approached that early on, and unfortunately, we're met with a lack of desire to do that. So.
Other questions by board members?
Mr. Chairman, this is Member Nylander. Is the intent to, what's the date for the extension on this one? I've heard a couple of different dates, read a couple different dates. So.
Christopher Rose, for the record. The current date is November 5th, 2022, and we've requested a 1-year extension.
Okay, yeah, so you'd have a year, and then presumably you'd be back in front of us if you haven't been able to resolve the issue with Las Vegas and give us an update.
Correct.
Thank you.
Any other board member wish to weigh in with questions or a statement? If not, do we have a motion?
Mr. Chairman, this is Member Nylander. I would move for approval of item number 6B as stated on the agenda, and that would be conditioned that the approval, the extension would expire on November 5th, 2023.
Member Durrett, I second.
Motion for approval and second. Extension date so stated. Anything additional by board members? If not, all in favor, please say aye.
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 Any nays? Any abstentions? Matter carries. The date noted for extension. Thank you.
Thank you very much. Thank you.
That moves us to item number C, Deep Roots Harvest, Inc.
Thank you, Chair. Agenda item 6C is for Deep Roots Medical LLC. Deep Roots Medical LLC, or Deep Roots, was issued a conditional adult use distribution license T024 by the Department of Taxation on August 25th of 2017 within the Mesquite jurisdiction. In error, the conditional license record was not transferred over from the Department of Taxation records into Excella. The Cannabis Compliance Board system of record when CCB took over regulation of the state's cannabis industry. On January 25th, 2022, Deep Roots, together with the GPRP Distributors LLC, or GPRP, submitted a transfer of interest request number 22002 to the CCB requesting approval of Deep Roots 100% acquisition of GPRP, which owned active distribution license ID T095. Within the TOI being approved at the August 23rd, 2022 board meeting, Deep Roots acquired GPRP's T095 license. Deep Roots expressed its interest in co-locating both its T095 and conditional T024 distribution license, and would therefore like to pursue perfecting the T024 conditional distribution license, which initiated this request for an extension. On September 20th, 2022, Deep Roots legal counsel submitted a letter requesting an extension of time for the conditional distribution license. Deep Roots requests an extension to February 5th, 2023. Staff have communicated to Deep Roots that there are no areas of concern and has asked the licensee to be prepared to discuss its progress at the board meeting. I'm available for any questions, and John Marshall and Lori Rogich are present to give a brief presentation and address any questions you may have.
Yes, the licensees, if you'll state your name for the record, but we note that there were some miscommunications and failure to transfer appropriate records with the transition from the Department of Tax to the Cannabis Board. So there was a notice issue. I'd like to know kind of where you're at and what your plans are.
Good morning, Chairman Douglas, members of the board, Director Klimas, Chief Gilbert. My name is Lori Rogish, and I'm here on behalf of Deep Roots Harvest Inc. With me today is John Marshall. Mr. Marshall is an owner and the Chief Operating Officer of Deep Roots Harvest. He is also an experienced leader in the cannabis industry and has played a central role in the strategic transformation of Deep Roots into one of the most successful operations in our state. With that being said, we respectfully request an extension of time for the distribution license. We are ready for final inspection, and a short extension will allow us to perfect the license.
Note for the record that the extension request is for February of 2023. Is that your
Yes, it
request?
is.
Questions by the board? If not, we have no questions. Motion for approval.
Member Durrett, I move to approve the request for an extension under agenda item 6C, which would be valid until February 5th, 2023.
Member Merritt, second.
We have a motion. We have a second. We have any further discussion? If not, all in favor of the approval, please say aye.
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 Any nays, any abstentions? Hearing none, motion passes unanimously. Thank you.
Thank you very much.
That would now move us to item number 7, approvals and resolutions. Notice of final licensure, West 118 Investments LLC.
Thank you, Chair, members of the board. Steve Gilbert for the record. Agenda item 7A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. Today we have one to note. Two Skirts Cultivation Production LLC, or Two Skirts, applied for a medical cultivation and production license during the January 2018 Department of Taxation application period, and for adult use cultivation and production licenses during the June 2018 Department of Taxation application periods. As a result, Two Skirts was awarded conditional licenses for cannabis establishment ID C190, P125, RC190, and RP125 in the city of Fernley jurisdiction. The licenses were transferred to West 118 as a result of the board's approval of TOI number 21039 at its August 23, 2022 meeting. On September 15th, 2022, the CCB conducted a pre-opening and inspection and audit of the cultivation and production facility. The inspection and audit results revealed the facility was in compliance with NCCR and NRS, and a statement of no deficiency was issued on September 22nd of 2022, demonstrating West 118 has met the regulatory operation requirements. As a result, the CCB approved and issued final licensure to West 118 for its medical and adult use cultivation and production facility on October 6th of 2022. With that, Chair and members of the board, I'm happy to answer any questions.
Questions by board members? Hearing none, we'll move the agenda. This was on for discussion only. I'll leave with no comments today, except a good meeting with the industry as was echoed before, but the proof is in putting of the follow-up. And with that, to our executive director.
Thank you, Chair Tyler Klimas. For the record, couple updates and a couple notices for the board today. First is on a notice of petition we received from Fure, a company called Fure. We received this on September 13th, 2022. They were seeking to amend NCCR 10.080 to include as an approved method of cannabis waste disposal a process which includes chemicals that are considered non-hazardous, zero VOC, non-flammable oxide-free pigments, and contain enzymes for accelerated decomposition with optical brighteners for inspection markers. It's been communicated to the submitting party that our regulations currently allow for any process or another process if it's approved, submitted on behalf of a licensee or by a licensee and approved by board and board agents. And so as an informational item, this petition has been posted as materials online. Certainly encourage any interested party to review the materials. And of course, if any licensee wishes to utilize such technology, it should follow the normal submission and application process for an alternative method of destruction. Second update is an update on the petition this board received from White Pine County. Following last month's board meeting and at the board's request, staff and council have begun to draft the changes to regulations necessary to facilitate an open and competitive medical-only licensing round for any and all jurisdictions who did not participate in the initial medical rounds. So barring any unforeseen circumstances, we could notice for adoption the necessary changes for December's board meeting for board members to consider, given the notice requirements. And then following a 15-day review by the Legislative Commission, and then following any necessary 30-day notice of a licensing round, we could see a medical-only licensing round happen sometime in February. So that is an update on that petition, and I will be happy to provide further updates as we move forward. Also like to update the board on the petition we received on cannabis events that the board asked for the advisory commission to meet and study and make recommendations. The advisory commission did meet on October 4th. We had a good meeting. We sent some issues to our subcommittees on public health, public safety, and social equity. Those subcommittees will begin to meet starting Monday at 9 a.m. That'll be the subcommittee on public safety. The additional subcommittees will meet following Monday. So look forward to providing any kind of updates and any final recommendations over the next couple months from the advisory commission to the board. And finally, today, Member Durrett, you had asked about some legislative bills we are tracking. Well, I think you wanted to just begin the discussion as we move towards the legislative session. As you know, we have 3 BDRs submitted, one on the disciplinary process, one is a housekeeping BDR, and the other is on the portability of cannabis licenses in the rural areas. We are also currently tracking a small handful of BDRs that have been submitted. I imagine there'll be some additional BDRs submitted, and we certainly can update the board, and however you would like to discuss those at future board meetings, we can do that. So with that, that'll conclude my remarks, Chair. Happy to answer any questions that you or members of the board have.
Board members, any questions of our director?
Well, yeah, on the December agenda, can we continue to discuss our BDRs and BDRs that we're watching that will impact us?
Sure.
It'll probably be very interesting come January because things will settle out in December after the elections. With that, we will note that our next meeting is scheduled for November 15th, 2022. And any items for future agendas are that you wish to refer to Director? If not, if we can have our second round of public comments. Las Vegas. Yes, sir.
Good morning. Excuse me. Good morning, committee. My name is Timothy Eliato, and I'm representing Kimo Vario. Excuse me. Don't mind. Sorry.
Just take a deep breath.
Oh boy. Alrighty. So, I'm here to speak on the social equity, and I would just like to state that even though AB 341 it was a major milestone for the cannabis industry, I would like to acknowledge that it failed to address the root cause of the lack of diversity in MME licensee ownership to the marginalized groups in our community, which is in reference to the data that was released by the CCB. A subcommittee was established to review and recommend suggestions for the social equity program. I believe that was last year. I attended each and every one of those meetings. During the previous legislative session, Assemblywoman Chandra Armstrong suggested I meet with Aisha Goins, who is, I believe, the president of the CEIC, to discuss and draft the recommendations for the social equity program. It never happened. Every time I followed up, she always ignored me. Even till today, I received a text message from Commissioner Take insisting that I go to the website if I need any help. Aisha Goins to discuss the draft recommendations for the social equity program in order to balance the scale of representations for various groups instead of a single agenda. But unfortunately, Aisha ignored all the attempts to meet up and proceeded with a single agenda that resulted in a final draft of the social equity program as we have it now. Earlier, you heard this young lady, Miss Rachel, discuss about the predatory investors. There's a reason why everything is in this situation. I just wanted to show what it meant to be a cannabis patient and what led us to this. What social equity means. For those that were part of this industry that were written off by SB 374 that was introduced, drafted by, at that moment, Senator Tick. That was the reason why the whole social equity program was established, was to basically find a way to write in those that were written off. That never happened. I'm here to show achievements that those that you have written off have been able to achieve with the University of Texas, Texas A&M, in terms of clinical trials and clinical research. I'm a plant breeder. I'm a cultivator. I never got the opportunities my colleagues had. Before the CCB was established, well, it was a transmission between the Department of Taxation. At that time, I had written up, and basically I was working for an established lab by the name of Cannabis. And through the experience working for the lab, I came up with a draft regulation as a memo for the basically as a recall procedure for all tested materials. I submitted it to the state, I submitted it to the Department of Taxation, and I submitted it to different entities, and it ended up being a part of the draft that was written for the review of the For the review of the, for the recall procedures of cannabis in the state of Nevada. That's what it is intended for. And a lot of these recommendations are what made it to the final draft. So long story short, I spoke with investors. I'm currently in the process. I did not qualify for social equity. Regardless of everything I have done for this industry, I have written SOPs for these cultivators. I worked in the lab. I helped establish everything that we know today about I'm sorry, I'm not trying to get emotional. It is your responsibility as leaders to look into how the subcommittee was established. Please look into it and understand that one single agenda does not represent the community. Please, we, despite of what this group is saying as a success, we are standing here to let you know it has not been a successful organization, and it has failed to basically address what it was intended to address. The solution is still what we're fighting for. And those with experience and expertise know better. And I can understand that those that are just now coming into the industry, trying to find their ways into the pathways, could just take whatever pieces that is given to them. But all I want to say is we need help, and we need you to stand up for what is right. It's not fair, and ownership is what we're all aiming for. Micro business loans. I was one of the first person of color, and this is my history. As a person of color, I established the first nonprofit organization before Senator Tick introduced SB 374. It was a nonprofit entity at that time because that's the model that we had before the for-profit model was introduced. I helped kids with various rare diseases because I am diagnosed with Ehlers-Danlos syndrome, hypermobility type 3. That's the reason why we established the Cannabinoid Wellness. It was co-sponsored by the U.S. Pain Foundation. Only reason why we weren't able to move forward with an entity was banking. The lack of having access to banking is what held us behind. What we wanted to address with a social equity program was to have a pathway to micro businesses loan so people like myself could basically have access to this capital so we could establish these businesses. It's not to give a whole chunk of money to one group organization that is supposed to help us, but in reality, it does absolutely nothing. Thanks for your time.
Thank you. Additional public comment, Las Vegas.
Hello, my name is Ron Baker. I'm the outreach coordinator for CEIC and the class facilitator for the Cannabis Business School. I'm here to say my door is always open. I'm at the office sometimes 10 to 12 hours a day. Our office is 633 South 4th Street, right on the corner of 4th and Garces, right across from Canistars, which is one of our community partners. We find ourselves in the community almost daily, going to events and these type of things. We've extended our hand to this gentleman multiple times. He's not showed up at our offices. Like I said, our office is open. We have a gentleman there, our vice president, he's there at 7 in the morning, sometimes until 8 at night, and I'm there sometimes until 10 at night. If you need my number, 702. I have your number. Thank you. Yeah, we communicated through text. If you can't reach anybody else, I'm the outreach coordinator. You can contact me. Come by anytime you need to. So whatever information that he needs to get to Commissioner Goings, he can definitely get it to me, and I would definitely get it to her. She's there all the time. So like I said, our offices are open. Everybody knows where our office is, right on the corner of 4th and Garces. We have nothing to hide. Thank you.
Additional public comment, Las Vegas.
Thank you for this opportunity one more time, and I will be brief. Rachel Lee for the records. About a year ago, I came into this room and I met the young lady Aisha Goins, and this was the first time that I've seen anybody do anything for the community. Where I came from is that if we were to try to do anything, there was consequences. Um, and so seeing so many establishments being granted licenses and not too many being of color, to hear a lady stand up for something and to try to attempt to help someone with something is a plus for me. I don't want to stand in front of, in a room and hear anyone belittle the efforts that the entire board has tried to do and the people that they trusted to try to do the work for the community. I see this lady in the community helping, and I've seen her tirelessly try to do all she can do, but she is not God, and she is not promising anything to anyone, but she is at least trying to do something. And I really appreciate that, and I appreciate you entrusting her. But to try to belittle her efforts and say that she's not doing nothing would be a lie to me. Thank you.
Additional public comment, Las Vegas. Any, yes, sir.
Chairman Cooks for the record. Good morning, and I just wanted to thank you for the ease of the consumption lounge application process. We've successfully submitted for our cohort, the Pathway to Ownership program, successfully submitted our first application yesterday. It was a breeze. We will be submitting 4 more today. So I just wanted to thank you for the work that you've done and for leaving us. Thank you.
Any additional public comment? Las Vegas. Do we have any public comment in Northern Nevada out of Carson City? Sia.
Hi, Will Adler for the record with the Sierra Cannabis Coalition. Just quickly, is there a way we could request sort of a Zoom link or participation link for the CAC meetings? Cannabis Advisory Commission seems to be held down in Vegas solely, and there's a Northern Nevada link. So if there would be a way to just ask for a Zoom link to comment directly, I'd appreciate that. Thank you very much.
Anyone else from the north who wishes to enter a comment? Seeing none, that would close our public comment at this time. Prior to adjournment, just a kind of a public service message. Elections coming up. Please get out and vote for whoever you wish to vote for, because if you don't, you can't holler and scream that it was wrong. As to the industry, both social equity and for those in operations, also get out and vote so that you have a pathway to talk to our elected officials to make whatever changes you may think are appropriate. With that, unless there's anything else, we will adjourn our meeting.